Garrett Hollins walked into his Tulsa mansion and found the wheelchairs missing, not moved, but gone, and the woman he'd just fired kneeling with his paralyzed twins, their braces removed, their toes pressing into the mat, as if testing ground they'd been told would never support them again. Security moved before he could ask who authorized this, and within minutes she was escorted out, while lawyers called about liability and unauthorized treatment that could reopen a settlement everyone thought was buried. But here's what shattered everything. The woman wasn't just any maid. She was the home health aide from the accident 3 years earlier, the one he'd been forced to forget through sealed agreements he didn't remember signing. And the real devastation? He would discover his own signature on documents that suppressed his children's recovery to protect himself. Comment where you're watching from below and subscribe, because what happens next will question who the system actually protects. Garrett Hollins stopped in the doorway of the therapy wing before anyone noticed he was there, and in that suspended moment between arrival and acknowledgement, the wrongness of the scene assembled itself piece by piece in a way that made his lungs tighten before his mind could articulate why. The wheelchairs were gone, not folded against the wall where protocol dictated they should rest between sessions, not pushed into the adjacent storage closet, but absent entirely, leaving the polished floor of the Tulsa facility exposed in a geometry that felt deliberate rather than accidental, as if someone had made a choice that required concealment. The therapy mats were still warm beneath the overhead lights, faint impressions visible where weight had recently pressed into the cushioning, and across the room, the metronome he had commissioned from a supplier in Leipzig continued its mechanical tick, the sound filling the silence with a rhythm that suggested the session had not ended, but had instead evolved into something unscheduled, something unauthorized, something that made the hairs on the back of his neck respond to a threat his rational mind had not yet identified. She was kneeling on the far side of the parallel bars with her back to the entrance, a woman in the grey uniform of household staff, her shoulders angled forward in a posture of concentration that seemed almost reverential, and beneath her hands were his children, Ellery and Hollis, 8 years old, their leg braces removed and stacked neatly beside the mat, their bare feet pressed into the padding as though the floor itself were being tested for some quality only they could sense. No one spoke. The woman's voice was low, not commanding, but coaxing, and Garrett watched as Ellery's toes flexed in response, a motion so slight it might have been dismissed as reflex, except that it happened again, deliberately, in sequence, as if the body were remembering something the doctors had declared neurologically impossible after the accident that had rewritten their futures 3 years earlier on a fogged stretch of highway near Hinton, where a delivery truck had failed to yield and the settlement that followed had required more than money to close. Security was already moving past him before he could decide whether to interrupt or retreat, their presence a confirmation that the breach in protocol had been noticed elsewhere in the house. And the question forming in Garrett's throat was not about therapy techniques or medical risk, but something more unsettling, something that lived in the space between the missing wheelchairs and the woman's calm defiance. What exactly had she been preparing them for? Security reached the parallel bars before Garrett could formulate a question that did not sound like an accusation, and in the moment it took for the lead officer to position himself between the woman and the children, the entire dynamic of the room shifted from therapeutic intimacy to criminal interrogation, the kind of territorial reclamation that happens when authority realizes it has been circumvented rather than consulted. The woman did not rise immediately. She finished whatever count she had been conducting with Hollis, her hand steady against his ankle, and only then did she stand and turn to face the men whose job descriptions included preventing exactly this kind of unauthorized deviation from the medical protocols that governed every waking hour of the household. Her name, Garrett, would later learn from the personnel file he demanded within minutes of this confrontation, was Roslyn Cade, employed for 9 weeks through an agency in Oklahoma County, background cleared, references validated, nothing in her record to suggest she would kneel on a therapy mat and strip the braces from children whose spinal injuries had been documented by specialists across 3 states as permanent and irreversible. Garrett heard himself ask, who authorized this? The question came out sharper than he intended, carrying the edge of a man who had spent years constructing systems designed to ensure that nothing happened in his home without his knowledge, without layers of approval, without the kind of documentation that protected him from liability and from the chaos of improvisation. Roslyn did not apologize. She said only that the children had asked to try, that their words had been clear and persistent, and that she had listened, because listening, in her assessment, was not a luxury they could afford to postpone while forms moved through channels and specialists debated terminology. The answer was not defiance exactly, but it carried a kind of moral weight that made excuses feel irrelevant, and Garrett found himself caught between rage at the breach and something else, something quieter and more uncomfortable, a recognition that the question he was asking was not really about authorization at all, but about control, about who decided when hope was reckless and when recklessness was the only reasonable response to a ticking clock no one wanted to acknowledge. He fired her in the corridor overlooking Riverside Drive, the city below continuing its oblivious routines, while Roslyn gathered her coat without protest and said something that would loop in his mind for days afterward, a single sentence delivered without bitterness or plea. That time, whether the lawyers liked it or not, was running out faster than anyone in this house was willing to admit. If you need to see how far people will go to bury progress, you'll want to follow what happens next. The twins asked where she had gone before the door had fully closed. That night, after the household staff had been briefed on the incident and the therapy wing secured with new access protocols that required biometric authorization and supervisor presence, Ellery asked the question that Garrett had been preparing answers for since the moment Roslyn's coat disappeared through the service entrance. Where had Miss Roslyn gone, and why did leaving have to happen so quickly that goodbyes became impossible? The question arrived not with tears, but with the kind of quiet confusion that suggested the children understood more about power and decision-making than anyone had given them credit for, and Garrett found himself offering explanations that sounded increasingly hollow as he spoke them aloud, references to safety and procedure, and professional standards that meant nothing to 2 8-year-olds who had felt their toes respond to a voice that no longer had permission to speak to them. By morning, the neurologist in Edmond had reviewed the scans that had been transmitted overnight from Tulsa Regional, and Dr. Vikram Sethi, a man with 23 years of spinal injury experience and a publication record that made him one of the most cited researchers in his field, chose his words with the precision of someone who understood that hope could be weaponized as easily as it could be crushed. He did not use the word miracle. He spoke instead of residual signaling, of neuroplasticity windows that closed more slowly in children than adults, of unpredictable outcomes that defied statistical modeling but remained within the realm of biological plausibility. And every phrase he selected seemed designed to acknowledge what Garrett had witnessed in the therapy wing, without committing to a prognosis that could later be used against him in litigation that everyone in the room understood was already being contemplated by minds more focused on liability than recovery. The lawyers began calling before the coffee in the consultation room had cooled, their questions arriving in rapid succession from firms in Oklahoma County and Tulsa County, inquiries about staffing protocols and supervision gaps, and whether the household carried adequate coverage for unauthorized therapeutic interventions, the kind of language that made healing sound like a compliance failure rather than a possibility worth pursuing. In Rogers County, where the estate's security operations were coordinated through a private firm that specialized in high-net-worth residential protection, technicians began pulling footage from every camera in the house, slowing the recordings frame by frame, watching the repetition that medicine had declared futile months earlier. Lift, fall, lift again. Each small movement catalogued as evidence in a case that had not yet been filed, but was already shaping the boundaries of what could be discussed and what had to remain confined to speculation and fear. The question no one asked directly, but everyone was calculating, was simpler than the legal frameworks being constructed around it. Why were lawyers involved before doctors had finished their assessment? The security footage that Garrett finally forced himself to review 3 days after the incident did not show what he expected to see, which was recklessness or impatience or some visible indication that Roslyn had pushed the children beyond their tolerances in pursuit of results that would validate her own theories about recovery. Instead, the recordings showed something more unsettling in its repetition and care. Roslyn kneeling beside the parallel bars for 20-minute intervals, her hands guiding Ellery's foot through a sequence of movements so subtle they barely registered on camera. And then the pause, the waiting, the second attempt that came not from her insistence but from the child's own effort, the toes lifting and falling, and lifting again in a pattern that suggested not coercion but collaboration, a conversation happening in a language that medical imaging had declared extinct. What made Garrett stop the playback and rewind to a specific frame was not the therapy itself, but a detail visible in the reflection on the chrome surface of the parallel bars, where the angle of the camera caught Roslyn's face in profile for less than 3 seconds. And in that brief exposure, something in the shape of her jaw and the way she held her head triggered a recognition that felt less like memory than like a wound reopening before the scar tissue had fully formed. He knew that face, not from the agency file or the background check or any of the carefully constructed documentation that had accompanied her arrival at the estate, but from a morning 3 years earlier on a fogged stretch of Highway 54 near Hinton in Caddo County, where a delivery truck carrying commercial refrigeration equipment had failed to yield at an intersection obscured by ground mist and construction detours, and the impact had sent their vehicle into a drainage culvert at an angle that crushed the rear passenger compartment where Ellery and Hollis had been secured in seats that met every federal safety standard but could not account for the physics of a 7-ton truck traveling 48 miles per hour through a stop sign. Roslyn had not been the maid then. She had been the contracted home health aide on duty that weekend, hired through a service in Oklahoma County to provide overnight care while Garrett and his wife attended a conference in Dallas. And her name in the accident report had been different, shortened or altered in a way that made the connection impossible to trace unless someone was looking for it specifically, unless someone had reason to believe that the woman kneeling with his children in unauthorized defiance of every protocol was the same woman who had been present when their spines were severed and their futures were rewritten in the time it took for metal to fold and glass to shatter. The question that formed in Garrett's mind was not about therapy or credentials or even legal liability, but something far more threatening to the architecture of blame and settlement and closure he had spent 3 years constructing. Why had she come back? Garrett left the house before dawn without telling anyone where he was going, driving west through Canadian County and then Beckham County as the sky lightened over fields that looked the same as they had 3 years earlier when he had made this drive in the opposite direction. Returning from the hospital in Oklahoma City, where doctors had explained in language stripped of comfort that his children would never walk again and that the legal process ahead would require decisions made quickly, before memory became testimony and grief became liability. The address he had pulled from an employment database that should have been scrubbed led him to a rental house on the edge of Sayre, a single-story structure with vinyl siding and a chain-link fence that separated a small yard from the vacant lot next door. And when Roslyn opened the door, she did not look surprised to see him standing there with questions that had metastasized overnight from confusion into something closer to betrayal. She let him inside without preamble, and the living room smelled like coffee and contained almost no furniture, the kind of temporary arrangement that suggested she had not planned to stay long or had learned not to accumulate possessions that would complicate disappearing when circumstances required it. He asked her directly why she had come back, why she had concealed her identity, why she had risked everything to kneel on a therapy mat with children she had been legally required to forget. Roslyn did not offer excuses. She said she had been told to disappear after the accident, that the settlement negotiations had included a clause requiring her to sign a non-disclosure agreement and relocate outside Oklahoma County, that keeping her home health license and avoiding criminal charges had depended on her willingness to become a name without a face, a liability resolved through payment and silence. When Garrett insisted he had never seen such an agreement, had never authorized any terms beyond the financial compensation owed to the truck driver's employer and the standard medical malpractice protections, Roslyn walked to a filing cabinet in the corner of the room and returned with a folder that felt heavier than paper should feel. The documents inside were from Oklahoma County Superior Court, sealed under a judge's order that listed Garrett's attorney as the filing party, and halfway through the stack was a signature page that made his hands go numb. His own name in blue ink, dated 2 weeks after the accident, authorizing Roslyn's removal from the case and her permanent exclusion from any contact with the family in exchange for immunity from any claims she might later file regarding the circumstances of the crash. He stared at the signature and could not remember signing it, could not remember the conversation that must have preceded it, could not reconcile the person who had made that decision with the person he believed himself to be. Roslyn asked quietly what else he might have agreed to that his lawyers had never explained. The injunction arrived by courier on a Thursday morning, while Garrett was still processing the implications of documents he could not remember signing, and the legal language inside the envelope made it clear that whatever temporary confusion had existed in the days following Roslyn's dismissal had now hardened into coordinated institutional response. The filing came from a law firm in Tulsa County that specialized in medical malpractice defense, and the allegations listed across 6 pages reframed every moment of unauthorized therapy as evidence of child endangerment. Each toe movement documented in security footage now presented as proof of reckless experimentation rather than progress, the kind of narrative inversion that happens when lawyers decide that protecting liability matters more than acknowledging improvement. By Monday, a physician had been flown in from Allegheny County in Pennsylvania, a specialist in pediatric neurology whose credentials included testimony in 43 prior cases involving spinal cord injuries, and whose willingness to travel across state lines on short notice suggested a relationship with the legal team that predated this particular emergency. Dr. Marcus Venn testified during a closed hearing that Garrett was not permitted to attend, and the summary that reached him through his own attorneys described language carefully chosen to sound objective while serving a specific purpose. That unauthorized neuromotor stimulation in children with documented spinal trauma could cause secondary injury. That the appearance of movement could reflect muscle memory rather than neural regeneration, and that continuing such interventions without proper oversight constituted actionable negligence regardless of parental consent or apparent outcomes. The therapy room was locked by court order that afternoon. The parallel bars were photographed from multiple angles as if they were crime scene evidence. The metronome that had measured progress in increments too small for casual observation was logged into an evidence locker in Rogers County, its mechanical tick silenced by procedures designed to protect institutions rather than children. Subscribe if you need to see how deep the cover-up goes. Rosalind's name appeared in the filings as the primary threat, her methods described with adjectives that transformed care into danger: unsupervised, unorthodox, unauthorized, each prefix erasing the context of what had actually happened in that room when someone had chosen to listen instead of defer. The language made her sound like a charlatan rather than the person who had been present when the accident happened and who had returned knowing that success would be punished more severely than failure, because success required explanations that no settlement could survive. Garrett stood in the corridor outside the locked therapy wing and understood with sudden clarity that the system had never been designed to help his children walk. It had been designed to ensure that walking, if it happened, would remain legally invisible. The question forming in his mind was simpler than the injunctions being filed. What happens to the twins now? The statement came during a routine check-in with the child psychologist who had been monitoring Ellery and Hollis since the accident, a session that Garrett attended out of obligation rather than expectation, assuming it would produce the same gentle observations about adjustment and resilience that had filled previous reports. Dr. Ainsley Reeves worked from an office in Norman, specializing in pediatric trauma, and she had a way of asking questions that sounded casual but were designed to surface details that children often kept hidden from parents who were too close to their own grief to notice what was being said beneath the words. Hollis mentioned Miss Rosalind without prompting, and when Dr. Reeves asked what he remembered most clearly about her, the answer arrived with the kind of specificity that made the room go quiet in a way that felt different from ordinary silence. He said he remembered her crying the day of the accident, not the loud kind of crying that demanded attention, but the quiet kind that happened when she thought no one was watching, her hands shaking when she checked their pulses in the back of the crushed vehicle while they waited for the ambulance to navigate the construction detours on Highway 54. Ellery nodded and added that Miss Roslin had stayed with them the entire time, talking to them even when the paramedics said they probably couldn't hear. Her voice, the only constant in a situation where every adult seemed to be shouting instructions that contradicted each other. Garrett had not been present during those first minutes after impact. He had been in Dallas, receiving a phone call that turned a conference presentation into the longest flight of his life. And by the time he reached the hospital in Oklahoma City, the immediate crisis had passed, and the doctors were already using words like permanent and irreversible. No one had mentioned Rosalind's presence in detail, and the accident report he had reviewed in the weeks that followed had reduced her to a single line: contracted aid, on site, no injuries sustained. The settlement documents had erased her even further, transforming her into a legal liability resolved through payment and non-disclosure. But his children remembered her differently. They remembered someone who had cried, not because she was hurt, but because they were, someone whose hands had been steady enough to keep them calm while waiting for help that seemed to take hours to arrive. Even though the official timeline listed the response as 11 minutes from initial call to first responder arrival, that night, Garrett authorized what his attorneys described as a routine medical consult at a private clinic in Johnson County, Kansas, far enough from Oklahoma to avoid immediate scrutiny, but close enough to return within a day if the results required faster decisions. The doctor who agreed to conduct the scans did so under conditions that suggested she understood the stakes extended beyond medical diagnosis into territory where liability and truth were competing narratives. The question no one wanted to ask directly, but everyone was calculating: what would the scans show, and what would happen if they showed something that contradicted 3 years of authorized medical opinion? The scans conducted at the private clinic in Johnson County arrived in a sealed envelope 2 days later, and the radiologist who reviewed them chose her words with a precision that suggested she understood the images she was interpreting would become ammunition in battles that had nothing to do with medicine. Dr. Lena Cowrie had built her career on spinal cord research at the University of Kansas Medical Center, and when she spoke during the consultation that Garrett insisted remain off any official record, her language abandoned the cautious ambiguity that had characterized every previous medical assessment and delivered instead a conclusion that felt less like diagnosis than detonation. There was progress. Not theoretical, not speculative, but measurable and documented in the contrast enhancement patterns that showed neural pathway activation in regions the earlier scans from Oklahoma had classified as permanently dormant. The improvement was fragile, she explained, the kind of recovery that required consistent stimulus to maintain and could reverse if the work stopped now, but it existed in a form that could not be dismissed as residual signaling or misinterpreted reflex. When Garrett asked how long this progress had been occurring, Dr. Cowrie pulled up the comparison images from 6 months prior and pointed to differences that should have triggered immediate follow-up in any standard clinical protocol, but had instead been filed without comment in a system designed to document permanence rather than investigate possibility. The second document arrived not from Dr. Cowrie, but from an attorney Garrett had hired privately, someone outside the firms that had handled the original settlement and whose assignment had been simple: find out what else existed in sealed records that bore his signature. The file came from Cook County in Illinois, forwarded through channels that required judicial authorization to access, and the neurological assessment it contained carried a date from 8 months after the accident, a period Garrett remembered as focused entirely on adapting the house for wheelchair accessibility and establishing the medical protocols that would govern his children's futures. The report, authored by a specialist whose name Garrett did not recognize but whose credentials suggested access to institutional resources beyond what most families could afford, outlined findings that contradicted everything he had been told by the Oklahoma doctors. It noted potential for partial motor function recovery in both children, recommended aggressive neuromotor therapy within a specific developmental window, and then included a section that made the room feel smaller than it had moments before, a recommendation against pursuing such therapy due to liability concerns related to the ongoing settlement negotiations, with a notation that continuing stimulation could complicate the legal narrative by introducing variables that would reopen causation disputes and potentially expose the family to extended litigation. Garrett had approved this recommendation personally, his signature appearing at the bottom, alongside a date he could now place within the timeline of lawyer meetings and settlement conferences and decisions made in rooms where his children's voices were never present. He had known recovery was possible, and he had chosen control over uncertainty, protection over truth, closure over the risk that hope might demand something more expensive than money. The question forming now was not what he had signed, but what that signature had cost his children in the years since. Roslyn left town 3 days after Garrett discovered the documents from Cook County, disappearing in the way that people who have learned to navigate legal threats understand is necessary when staying becomes more dangerous than running. She did not leave a forwarding address or a phone number, and the rental house in Sayre was emptied by the time Garrett thought to drive back with questions that had multiplied faster than his ability to process their implications. The landlord said she had paid through the end of the month, but departed a week early, taking only what fit in 2 suitcases and leaving behind furniture that had come with the lease and a note on the kitchen counter thanking him for not asking questions he probably should have asked. Without Roslyn, the therapy that had been declared dangerous by court injunction and medical testimony continued in a form that required no parallel bars or professional supervision, only the children's own determination and a carpet in the upstairs hallway where no cameras had been installed, because privacy, in a house designed around security meant different things depending on whose autonomy was being protected. In St. Louis County, Missouri, where Garrett had taken the twins for what he told his attorneys was a short vacation, but was actually a calculated distance from jurisdictions where injunctions held immediate force, Ellery stood unsupported for 8 seconds while holding his sister's hand. The kind of milestone that would have triggered celebration in any other family, but in theirs demanded silence, because celebration meant acknowledgement, and acknowledgement meant exposure. In Boone County, they counted steps allowed in a hotel room that overlooked a parking lot where ordinary families loaded minivans with luggage and fast food, and the unremarkable exhaustion of travel. And Hollis made it from the bed to the bathroom doorway, 11 steps that took nearly 2 minutes to complete, but represented a distance that every specialist in Oklahoma had declared impossible without mechanical assistance or surgical intervention that carried risks no parent should accept. Each small gain raised a question larger than the achievement itself. If the children could progress without Roslyn, then what had she actually been doing in that therapy room? And why had her presence been treated as the threat rather than the catalyst? The answer arrived not as revelation but as accumulation. The slow recognition that Roslyn had never been teaching the children to walk, but rather teaching the adults what recovery looked like when it was allowed to happen outside the framework of settlements and liability management and medical protocols designed to limit risk rather than maximize possibility. Back in Tulsa, court filings updated by the hour. Lawyers from 3 firms coordinated language that would survive appeals. Garrett's wife stopped asking about the twins' progress and started asking instead about exposure timelines and media strategy. Outside the house, protocol demanded silence about children who were supposedly still confined to wheelchairs. Inside, one afternoon when no staff were present in the hallway, Hollis looked up at his father and asked a question that carried more weight than its simplicity suggested. Were they allowed to keep going? Garrett found Roslyn 3 weeks later at a bus stop in Lucas County, Ohio, snow collecting on her coat in the kind of accumulation that suggested she had been waiting longer than the schedule required. And when she saw him approach, she did not look surprised or relieved, but simply tired, in a way that had nothing to do with physical exhaustion and everything to do with the cost of caring about outcomes in a world designed to reward efficiency over empathy. He asked her why she had come back in the first place, why she had risked everything to kneel on a therapy mat with children she had been paid to forget, and her answer arrived without hesitation or defensiveness, stripped of the kind of justification that people usually offer when their choices have led to consequences they cannot control. She said the children were never the experiment. The adults were. The question had always been whether the people who claimed to love them most would choose their recovery over their own comfort, whether fathers who built empires on calculated risk would extend that same courage to uncertainties that carried no quarterly projections or exit strategies, whether systems designed to protect institutions could be dismantled by something as simple and devastating as a child asking permission to try. Roslyn had returned, not because she believed she could fix what the accident had broken, but because she wanted to know if anyone else would choose to see what was possible once fear stopped masquerading as prudence. Garrett drove back to Tulsa with that sentence playing in his mind on a loop that made sleep impossible and decisions unavoidable. The house felt smaller when he arrived, the hallways narrower, the security protocols more suffocating than protective. Court filings waited in his office, updated by lawyers who billed in 6-minute increments and measured success in settlements that protected everyone except the people they claimed to serve. Cameras monitored every room where the twins might demonstrate progress that would contradict 3 years of testimony, declaring them permanently disabled. His wife sat in the study with an attorney from Chicago, discussing media strategies for managing exposure if the truth became public. their voices clinical and detached in a way that made love sound like liability management. In the therapy wing that had been locked by court order and catalogued as evidence in a case designed to prevent what had already begun, the metronome sat silent in its evidence box, waiting for someone to decide whether measuring progress mattered more than managing perception. Ellery stood in the doorway, braces removed, one hand against the frame for balance, and asked the question that made every contract and injunction and settlement agreement irrelevant. Were they allowed to keep going, or did the adults need more time to decide what mattered? The metronome ticked again, not from mechanical winding, but from the choice that stopping it now would cost more than money. It would cost the only truth that mattered, the one his children had been trying to tell him since the day Roslyn knelt beside them and decided that listening was worth more than permission.